A 9-0 Supreme Court decision just dropped, and if you carry a firearm in your vehicle, this ruling changes the rules of every single traffic stop you will ever have for the rest of your life. Not some of them, not the complicated ones, every single one. And here is the part that should make you stop whatever you are doing right now and pay full attention. Most gun owners are not going to hear about this ruling for months. Some of them are going to find out about it the worst possible way. Standing on the side of a highway, hands visible, watching an officer methodically tear apart their vehicle, wondering how their completely legal firearm just turned into a 4-hour nightmare and a court date they never saw coming. You are watching this right now, which means you have a chance to not be that person. In the next few minutes, I am going to break down exactly what the Supreme Court decided, why every single justice agreed, including the ones who never agree on anything, what it means the next time you get pulled over, and the specific mistakes that gun owners are still going to make even after this ruling that will land them in serious legal trouble anyway. Stay with me through the whole thing because the section most people skip is the one that actually saves them. Let me tell you about a man named David Morales. He was driving home on a Tuesday afternoon in a state where he had a valid concealed carry permit. He had owned firearms legally for over a decade, never a criminal conviction, never so much as a serious traffic violation. He was, by every definition of the phrase, a law-abiding gun owner doing everything right. He got pulled over because one of his taillights was out. That is it. That is the entire reason the stop happened, a $12 tail light bulb. The officer approached the vehicle, asked for license and registration, and then asked if there were any weapons in the car. David did exactly what responsible gun owners are told to do. He calmly informed the officer that yes, he had a legally owned firearm in the center console, and that he had a valid concealed carry permit for it. He handed over his permit along with his license. He was cooperative, he was calm, he was completely transparent. He was doing everything by the book, hiding nothing, showing full respect for the law, and then the officer told him to step out of the vehicle and proceeded to conduct a full search. Not a safety glance at the console where the gun was located, not a quick visual sweep of the driver's seat, a complete, thorough search of the entire vehicle. Glove box, back seat, trunk, every compartment. The officer's stated reasoning was straightforward, and it is a line that has been used at the roadside for decades. Because there was a firearm present, he had automatic safety concerns, and those concerns gave him the legal authority to bypass the warrant requirement entirely. During that search, the officer found a small amount of prescription medication that was not in its original labeled bottle. David had a valid prescription, but because the medication was not in the pharmacy bottle, it technically violated a state regulation that David, like most people, did not even know existed. He was arrested. His firearm was confiscated. He spent a night in jail and thousands of dollars in legal fees defending himself against a charge that was ultimately dismissed. But here is the legal question that came out of that stop, the one that made its way all the way to the United States Supreme Court. Did the officer have the legal right to search that vehicle in the first place? And the answer that came back, unanimously, with all 9 justices in agreement, is going to reshape how every traffic stop involving a firearm works going forward. To understand why this ruling matters so much, you need to understand the collision that was happening at the heart of this case. 2 constitutional rights sitting directly against each other. The Second Amendment gives you the right to keep and bear arms. That is settled law. The Supreme Court has affirmed it multiple times. You have a constitutional right to own a firearm. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. That means the government, including law enforcement, cannot search your property without either your consent, a valid warrant, or what the law calls probable cause. And probable cause is a specific legal standard. It means there has to be a reasonable basis to believe that a crime has been or is being committed. Not a hunch, not a feeling. Not a what-if scenario playing out in an officer's head, actual, objective, articulable evidence pointing to actual criminal activity. Now here is where the problem was happening before this ruling. Some lower courts and some police department training programs were operating under a theory that went something like this. A firearm in a vehicle creates a safety risk. That safety risk gives officers a justified reason to search the vehicle. Therefore, a legal gun equals probable cause, which equals the officer can search your car. Read that again slowly, because what that logic actually means is devastating. It means that exercising your Second Amendment right, doing something the Constitution explicitly protects, automatically strips you of your Fourth Amendment right. You have a legal gun, therefore you can be searched without a warrant. And when those lower courts sided with that logic, they were effectively telling tens of millions of law-abiding Americans that they were forced into a twisted, impossible choice. Exercise your right to self-defense and forfeit your right to privacy, or keep your privacy and give up your firearm. Pick one. You cannot have both. Think about how fundamentally wrong that is. You are being penalized legally for doing something legal. That is the argument that made it to the Supreme Court. And that is the argument that 9 justices, conservative and liberal, appointed by Republican presidents and Democratic presidents, looked at and said no. Absolutely not. That is not how constitutional rights work in this country. The ruling was direct and it was clear. The court held that the mere presence of a legally owned firearm in a vehicle does not constitute probable cause for a warrantless search. Full stop. Legal gun ownership is not suspicious activity. It is constitutionally protected activity, and constitutionally protected activity cannot serve as the basis for stripping away another constitutional protection. The court went further than just the holding. In the written opinion, the justices addressed the broader principle at stake. They made it crystal clear that if police were allowed to treat a legal firearm as an automatic justification for an invasive search, then tens of millions of peaceful Americans would instantly lose their Fourth Amendment privacy protections the exact moment they chose to exercise their Second Amendment rights. A citizen, the court said, cannot be punished, targeted, or treated as a criminal suspect simply for doing something the United States Constitution explicitly protects. In plain English, you do not have to choose between your Second Amendment rights and your Fourth Amendment rights. You get both at the same time, in the same traffic stop. Now, a quick but important note here. What I am giving you is educational information based on the court's ruling. It is not legal advice for your specific situation. Laws vary by state, facts vary by case, and if you are dealing with a real legal issue, you need a real attorney. What I am doing here is helping you understand your rights, so you are informed going into every drive you take with a firearm in that vehicle. But here is why this particular ruling carries extraordinary weight. It was 9-0. In a Supreme Court that is famously divided on almost everything, every single justice reached the same conclusion. That kind of unanimity sends a message that goes far beyond the specific facts of this case. It tells every lower court in America, every police department in America, every prosecutor in America, this is not a close call. This is not a gray area. When the court splits 5-4, it signals that the law is unstable and vulnerable to being overturned. When all 9 stand together, the debate is over, the door is locked, and the constitutional boundary has been permanently set. Now let me explain a legal doctrine you need to know about because it sits right at the center of this ruling. It is called the automobile exception, and it has been around since 1925. Here's how it works. Normally, police need a warrant to search your property. But courts recognized long ago that vehicles are different from homes for 2 reasons. First, people have a lower expectation of privacy in their cars than in their houses. Second, and more practically, cars can move. If an officer has to wait for a warrant while your vehicle is sitting at a curb, you could drive away and any evidence could disappear. So the automobile exception says that police can search your vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. That exception is still valid after this ruling. Nobody is saying police can never search a car without a warrant. What the Supreme Court said is that probable cause has to be based on evidence of actual criminal activity. Here is why this matters so deeply. In the years leading up to this ruling, some courts were essentially saying that a firearm in the vehicle satisfied the probable cause requirement for the automobile exception. Gun equals potential evidence of a crime equals we can search. Aggressive prosecutors and lower courts had been stretching that logic far past any reasonable boundary, using it to conduct fishing expedition vehicle sweeps on citizens who had done absolutely nothing wrong. The Supreme Court looked at that logic and dismantled it completely. A legal firearm is not evidence of a crime. It is evidence of the exercise of a constitutional right. Allowing it to trigger the automobile exception would mean the exception swallows the rule. That police could search virtually any law-abiding gun owner's vehicle just by claiming the gun made them nervous. The court closed that door. Hard. Now let me make this as practical as possible with real scenarios because knowing the legal theory is only useful if you understand how it plays out on the side of the road. Scenario 1. You are driving with a legally owned firearm in your vehicle. You get pulled over for speeding. The officer asks if you have any weapons. You inform him that you have a legal firearm and show your permit. Under this ruling, that information alone, the existence of a legal gun with a valid permit, cannot be used as justification to search your vehicle. The officer needs a completely separate basis for probable cause. Scenario 2. Same stop, same gun. But this time, the officer says he smells something suspicious, or he observes behavior that goes well beyond ordinary traffic stop nerves, or there is something else concrete he can point to. Now, you are in different territory. The court was clear that this ruling applies to the gun in isolation. If there are what the law calls additional articulable facts, specific observable things the officer can point to that suggest actual criminal activity, the analysis changes entirely. Scenario 3. You are in a state where carrying requires a permit and you either do not have one or it is not valid in that jurisdiction. Now, the presence of the firearm is potentially evidence of a crime because carrying without a valid permit where one is required is illegal. This ruling does not protect you there because you are not exercising a legal right in that moment. You may be committing a crime. This distinction is the one that most people are going to miss. The ruling protects legal gun ownership from being treated as suspicious. It does not create a magic shield around your vehicle. It does not protect illegal possession. It draws a clear line between constitutional activity and criminal activity and says the former cannot be used as evidence of the latter. Now, I want to be straight with you here because some people are going to oversell this ruling and leave gun owners with a false sense of security. So here's the honest version of what can still go wrong. Officer ignorance is real. Not every officer is going to know about this ruling immediately. Police departments take time to update training. Some officers are going to continue operating under old assumptions. That does not make their actions legal. It means you need to know your rights well enough to protect them in the moment, calmly, without physical confrontation, and then fight it out in court later with an attorney if necessary. Pretextual justifications are still possible. An officer who is determined to search your vehicle can usually find something to point to: slightly tinted windows, an air freshener on the mirror, nervousness during questioning. Courts have historically been permissive about what counts as reasonable suspicion, which is a lower standard than probable cause. This ruling addresses probable cause for a full search. It does not eliminate an officer's ability to build a case using other observations. State law complexity matters enormously. The Supreme Court ruling establishes a federal constitutional floor. But gun laws vary dramatically by state. If you are carrying in a state with specific permit requirements, transport laws, or magazine restrictions, there may be state-specific reasons an officer could claim probable cause that have nothing to do with the federal ruling. Know the laws of every state you drive through. And then there is consent, the one that trips up more gun owners than anything else combined. If you consent to a search, this ruling does not help you. None of the Fourth Amendment protections help you if you voluntarily give them up. The moment you say, sure, go ahead when an officer asks to search your vehicle, you have waived your rights for that stop. Practice saying the words before you ever need to say them in real life. I do not consent to searches. Those 6 words, said calmly and clearly, are your most important legal tool at the roadside. Here is the other piece of this ruling that the mainstream coverage is almost completely ignoring. This decision does not just protect you during the traffic stop. It creates a foundation for challenging evidence obtained in past and future unconstitutional searches. Under the legal doctrine known as the fruit of the poisonous tree, if the initial basis for a search is unconstitutional, every single piece of evidence found as a result of that search is legally contaminated. Your attorney can file a motion to suppress, forcing the judge to throw that evidence out entirely. It does not matter what the officer found. If the search started illegally because they treated your legal gun as probable cause, the state's case can collapse before it ever reaches a jury. If you have a pending case that involves a vehicle search where a legal firearm was the stated reason for that search, call your attorney today. Show them this ruling, not tomorrow. Today. There are time limits on legal challenges and evidence does not wait around. Now let me give you the practical step-by-step protocol for every traffic stop when you are carrying. This is the part worth writing down. Step 1. The moment you see those flashing lights, signal, pull safely to the right, and stop. Turn off your engine. If it is dark, turn on your interior dome light. Roll down your driver's window and your passenger window if your windows are tinted. Place both hands flat on the steering wheel at 10 and 2 and keep them there. Do not reach for anything. Not your registration, not your permit, not your phone, nothing. Hands visible on the wheel. When an officer approaches a vehicle, their primary concern is what they cannot see. You eliminate that concern before they say a single word. Step 2. Stay calm and breathe. This sounds simple, but it matters more than most people realize. Visible, extreme nervousness combined with other factors is exactly what officers point to when they claim reasonable suspicion. Slow your breathing. Speak in a normal, steady tone. Step 3. Know your state's disclosure requirement before you ever get behind the wheel. Some states require you to proactively inform an officer that you are carrying. Some states only require disclosure if directly asked. Some have no requirement either way. This is research you need to do today, not while you are sitting in your car at 2 in the morning trying to remember something you read somewhere once. When the officer asks for your license and registration, look them in the eye and state exactly what you are about to do before you move. My license is in my back pocket and my registration is in the glove box. I'm going to reach for them slowly right now. Say it before you move. Every time. Step 4. If you disclose, do it clearly and without alarming language. Never say I have a gun. Instead, say this. Officer, I want to let you know I'm a licensed permit holder and I have a legally secured firearm located in my center console. Short, clear. factual. No dramatic delivery. No reaching toward the firearm. Just calm information stated once. Step 5. If the officer asks to search your vehicle, understand what that question actually means. They are asking for your voluntary permission because they know they do not have the legal probable cause to do it without your consent. This is the ultimate fork in the road. If you say, sure, go ahead, you have signed away every Fourth Amendment protection you have, and this Supreme Court ruling cannot help you after that point. Your response is simple, and it does not require aggression or explanation. Officer, I respect your job, but I do not consent to any searches of my vehicle. That is all. You do not need to cite case names on the shoulder of a highway. Just those words stated calmly and clearly. Step 6. If the officer searches anyway, do not physically resist. This is critical and non-negotiable. Do not touch the officer. Do not block the search physically. Do not escalate the encounter in any way. What you do instead is speak clearly for the record. Say once out loud, I do not consent to this search. Say it calmly, with enough volume that if there is a dash cam or a body camera running, your words are captured on audio. That spoken statement is the exact piece of evidence your defense attorney will use later in a courtroom to demonstrate that the search was conducted entirely against your will. You win this fight in court, not on the side of the road. Step 7. The second the stop is over and you are legally released, pull into the nearest safe parking lot and document everything immediately while the details are fresh. Write down the officer's name and badge number, the patrol car number, the exact time and location of the stop, the reason the officer gave for stopping you, the exact questions asked, and your exact responses, whether a search was conducted and what reason was given. Memory degrades fast and details matter enormously in court. Get everything down in writing before you drive another mile. Step 8. If you believe your rights were violated, contact a qualified firearms defense attorney immediately, not in a few days. The sooner an attorney is involved, the better your options are. Evidence gets preserved. Footage does not get deleted. Time limits do not run out on you. Let me zoom out for a moment because this ruling means something larger than just traffic stops and firearm disclosure. This is the most divided Supreme Court in modern American history. Justices who cannot agree on almost anything, unanimously affirming that constitutional rights are not designed to cancel each other out. The Second Amendment and the Fourth Amendment are both in the Bill of Rights. They were written by the same people at roughly the same time for the same purpose, to protect individual Americans from government overreach. The idea that exercising one would eliminate the other is fundamentally incompatible with every principle those amendments were built on. All 9 justices saw that. And they said so clearly and without reservation. That matters beyond just this specific case because there are other areas where this same principle is going to come up. Digital searches of records connected to legal gun purchases, surveillance of firearms retailers, database tracking of lawful transactions. In all of those situations, the same foundational question applies. Does exercising your Second Amendment right give the government a basis for treating you as a suspect and eliminating your other constitutional protections? After this ruling, the answer courts are going to start from is no, and that is a meaningful and lasting shift. Here is what you need to do right now, today, before your next drive. Look up your state's specific laws on firearm transport and disclosure requirements. Know whether your permit is required, where the firearm must be stored, and whether disclosure is mandatory. Do not guess. Look it up. If you regularly drive across state lines with a firearm, research the reciprocity laws for every state you drive through. Concealed carry permits are not universally honored. Driving into the wrong state with a firearm you believed was legal to carry can make you a criminal before you realize it happened. Practice your traffic stop protocol out loud. Know where your firearm is. Know where your permit is. Know the exact words you are going to say. The middle of an actual traffic stop is not the time to figure any of this out for the first time. And if you have ever had your vehicle searched during a traffic stop where the officer cited your legal firearm as the reason, talk to an attorney. This ruling may be directly relevant to your situation. Here's what you need to walk away knowing from everything covered here. The Supreme Court just ruled 9-0 that having a legal firearm in your vehicle does not give police automatic authority to search your car without a warrant or independent probable cause. Your Second Amendment rights and your Fourth Amendment rights exist together. Exercising one does not eliminate the other. Legal gun ownership is not suspicious activity, and it cannot legally be treated as such. This ruling is a significant win for every honest, law-abiding gun owner who is trying to do everything right. It closes a legal loophole that was being used to justify unconstitutional searches of vehicles belonging to people who had done absolutely nothing wrong. It gives you and your attorney a powerful legal foundation to stand on if your rights are ever violated at a traffic stop. But it is not a magic shield. You still need to know your state laws cold. You still need to carry proper documentation. You still need to be smart, calm, and deliberate during every police encounter. And you still need a real attorney if you are facing real legal trouble. The law just moved meaningfully in your favor. Make sure you understand it well enough to use it. Stay safe, stay fully informed, and stay completely legal out there. The road ahead always belongs to the well-prepared.